Hi everyone, good morning. My name is Shivani and I'm representing Judicial Mascots today. And the topic that we're going to read about is anticipatory bail. So, what is anticipatory bail? Anticipatory bail and its drafting under Section 438 of CRPC. Anticipatory bail, where any person has a reason to believe that he may be arrested on the grounds of having committed a non-bailable offence, he may apply to the High Court or the Court of Session for a direction under this section that in the event of such arrest, he shall be released on bail and the court shall provide him anticipatory bail after taking consideration the following factors. So, what are the factors that one person has to take into consideration? The court has to take into consideration while granting anticipatory bail. So, the factors are first is the nature and gravity of the accusation, as in how grave the offense is and what kind of offense has been committed or is preceded to be committed. The antecedents of the applicant, including the fact as to whether he has previously undergone imprisonment on conviction by a court in any respect of any cognizable offense. Then the possibility of the applicant to flee from justice, whether he will abscond or not. Then the accusation has been made with the object of injuring or humiliating the applicant by having him so arrested. Either reject the bail application forthwith or issue an interim order for the grant of anticipatory bail, which means whether this FIR has been lodged against the person in order to, tarnish the name and the image of the person. What is the nature and gravity of the accusation that has been committed? What is the antecedents, whether the accused has any antecedents against him, and what is the possibility of the applicant to flee or abscond? After that, where the High Court or the Court of Session grants an interim bail to the applicant, then the court forthwith a show cause notice attested with a copy of such order served to the public prosecutor and the superintendent of police with the view to give the public prosecutor a reasonable opportunity of being heard when the application shall be finally heard by the court. Once an interim bail is granted, a show cause notice attested with that copy of that order of that interim bail, it will be given to the public prosecutor and the superintendent of police so that a reasonable opportunity could be given to the public prosecutor to be heard in the court. The presence of the applicant seeking anticipatory bail shall be obligatory at the time of final hearing of the application and passing of final order by the court. If on an application made to it by public prosecutor, the court considers such presence necessary in the interest of justice, the court will consider whether or not and in the interest of justice, the presence of the accused over here, who is the applicant seeking the anticipatory bail, is necessary or not, and he shall be present accordingly at the time of the final hearing when such an order is to be passed. Who is eligible to obtain anticipatory bail? Now, any person who has a reason to believe that there is a chance to get him arrested on false or trump up charges due to enmity with someone, or he fears that false case is likely to be built up against him, he has the right to move to the Court of Session or High Court under 438 of the Code of Criminal Procedure for grant of bail in the event of this arrest, and the court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. Section 438 gives the power to obtain an anticipatory bail. So, who obtains an anticipatory bail? If a person, if he has a reason to believe that someone might put a false case against him, or if due to enmity or any other such reason, there is a possibility that a case may be put up against him which is frivolous in nature, which is false, then he has the right to move to Sessions Court or the High Court under Section 438 to grant him bail to take a permission for the prior granting of bail so that as soon as in the moment he is arrested, he shall be released on bail. Then an accused who has been declared as an absconder or proclaimed offender under section 82 of CRPC is not cooperated with the investigation should not be given an anticipatory bail. So a person who is an absconder, which means a person who has absconded or fled from the interest of justice or is termed as a proclaimed offender, a notice will be given when a person is termed as a proclaimed offender. In such cases, the person will not be granted any anticipatory bail. So, Supreme Court in the state of Madhya Pradesh versus Pradeep Sharma held that when a person against whom a warrant has been issued and is absconding or concealing himself in order to avoid the execution of such warrant and declared as a proclaimed offender in the terms of Section 82 of the Code, he is not entitled to relief of anticipatory bail. Now, what are the conditions for obtaining the anticipatory bail? The High Court or the Court of Session may include such conditions in the light of the facts of a particular case, as in the conditions depend on fact to fact, case to case basis, but there are certain criteria that has to be followed in each and every case. What are those criteria? First, a condition that the person shall make himself available for interrogation by the police officer as and when required. The condition that the person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts or to the court or to any police officer. In this case, it would be the threatening of the person, threatening the witnesses, and the likes of it. The condition that the person shall not leave India without previous permissions of the court. Now, an accused is free on bail as long as the same is not cancelled. The High Court or the Court of Session may direct that any person who has been released on bail to be arrested and commit to him custody on an application moved by the complainant or the prosecution, which means a person an accused is free, which means a person who is an accused, once he is granted bail, his bail will not be granted or his bail will not be cancelled on just any grounds. However, for once he is released, his application for cancellation of bail may be given in the court of law, in the High Court or the Court of Sessions, as the case may be, and by such an application by the complainant, if accepted by the court, then in such a case, the bail which was granted to him, the anticipatory bail which was granted to him, shall be cancelled under the same section. What is mandatory bail? And Section 167 Clause 2 of CRPC empowers the judicial magistrates to authorize custody of a person accused in cases wherein the investigation cannot be completed in 24 hours. Which means if an investigation is not completed under 24 hours, then the person authorizes the custody of an accused cases, and it provides for the maximum period of the custody that can be authorized. In such a case, within the maximum period, if the investigation is not completed, then in such a case, a bail may be released, the person will be released on bail, whatever the nature of accusation is against him. So what we say is that the bail is a right, while arrest and non-granting of bail is upon the discretion of the court. So in the case of Nadwar Parinda versus State of Orissa, the Honorable Supreme Court noted that accused has the right to be released on bail under the provision, even if the offense that he committed is serious and is ghastly types of crimes, which means that regardless of the nature of the offense, if the investigation is not completed under a specific period of time as stated, then in such a case, the accused has the right to move to court and to be granted bail. Now comes the drafting of the anticipatory bail. So here is the drafting of the anticipatory bail. First is this is the drafting in the High Court of Gujarat, which means and we can go under Sessions Court as well as High Court. In this particular draft, it is in the High Court of Gujarat. So what is the nature of the draft? First is you write the name of the applicant, who would be XYZ person, and then you write the age, the occupation, where the person resides, and what is the applicant. In our case, the applicant was accused number 2 versus the state of Gujarat. Then we write the application under 438 of the code in connection with complaint with CR number so and so, dated so and so, lodged at so and so police station. After that, we write most respectfully sure that by way of this application, these are the grounds that remain, these are the ones that remain similar in almost every single draft application. What do we write? By way of this application under section 438 of the CRPC, the applicant placed before this honorable court to grant him anticipatory bail in connection with an FIR bearing CR number so and so, at dated so and so at so and so police station. The copy of the said FIR is annexed hereto and marked as Annexure A of this application. Then we write the facts of the case, which is the story of the prosecution is as under. It is alleged by the complainant that the accused number one, we write the name of the accused, being into so and so business, is a reputed business in the so and so industry in Surat Circuit. Surat was the name of the city that we mentioned earlier, and is a proprietor of ABC Fashion, hereinafter referred as the company, with having office at whatever the address of the office is. That the complainant in the impugned FIR has further alleged that he met accused number one via accused number two, and in our case, we are asking for anticipatory bail for the accused number two, who is the applicant in the present application, here and after referred as the applicant, in the pretext of doing business with accused number one and supplying dash material to the company with a mutual agreement to pay the bill within 40 days from the date of delivery. It is further alleged by the complainant that the complainant, after the first time, had supplied the so and so materials to accused number one on the date which was paid within time and mutually agreed by the complainant and accused number one. Further, it is alleged by the complainant that after the delivery of goods and receiving the payments, he had gained trust on accused number one. Then, as per the request of accused number one, the complainant had supplied a total of so and so amount of materials of different quality worth rupees so and so to the complainant, to which the complainant had further alleged that he had also received the delivery challan receipt with the stamp of accused number one's company. Then the further facts talked about the complainant and whatever is alleged in the FIR and how much amount of money is remaining to be paid, which is the cause of action. Now, the cause of action arises when accused number one had not paid a payment rupees so and so in the agreed timeline, which was 40 days, and then after making repeated requests, the complainant had returned so little amount of money, amount of material worth rupees so and so. After that, the complainant, apart from the material that was returned back to him, he had to recover so and so amount of rupees, and for which the complainant used to contact accused number one and visit his office. Till date, the money had not been received, hence the impugned FIR came to be registered. Now, this was the facts of the case. In the present case, the role of the applicant, the present applicant, and the accused number two is only to introduce accused number one to the complainant. That then we write down what it is that the applicant preferred anticipatory bail before the additional 13th additional district and sessions judge Surat within with a criminal miscellaneous application number so and so, and the same copy came to be rejected with an order dated so and so. Then we write a copy of the order dated so and so, passed by the learned 13th additional district and sessions judge Surat, is annexed herein and marked as Annexure B. Being aggrieved and dissatisfied with the order, the applicant therefore begs to prefer this application before the Honorable Court for anticipatory on the following grounds. Then we mention what are the grounds of the case. Life bereft of liberty would be without honor and dignity and would lose all its significance, meaning that is why liberty is first quintessence of a civilized existence. These are some of the grounds that remain same. That the first two grounds are the ones that remain same in almost every draft application of anticipatory bail. Then we write down what the on which grounds we are seeking for this specific case, which is over here, that the textile business involved in impugned FIR ABC Fashion and company belongs to accused number one. We are accused number two, and present applicant is nowhere involved in the alleged transaction, even as per the contents of the FIR. So he may be released on anticipatory bail. They submitted that the sole role of present applicant is that he had introduced the complainant to accused number one. Other than that, the present applicant has no direct or indirect contact with the transactions in the impugned FIR. That the present applicant has not committed any offense mentioned in the FIR, and goods delivered mentioned in the impugned FIR is not even collected by the present applicant. That the applicant has been falsely implicated in the alleged offense. It is submitted that the applicant is no way connected to the alleged commission of crime. The applicant herein most respectfully submits to this honorable court that the allegations made in the FIR, even if accepted in their entirety, do not prima facie constitute any offense or make out any case against the present applicant. It is respectfully submitted that the applicant belongs to a respectful state of the society. If the applicant is made to suffer criminal persecution, entire family would break down and irreparable loss would be caused to them, which cannot be compensated in terms of money. Therefore, Honorable Court may be pleased to grant release him on anticipatory bail. Then we have other grounds which are very similar, which is to be added under almost all of the cases pertaining to anticipatory bail, where we have Joginder Kumar versus State of Uttar Pradesh, the case related to anticipatory bail, and then we add another case. After that, after these similar grounds which are to be added in almost every case, we write down that the applicant asserts innocence and claim to have been robbed in the case only with malified intentions. Further, then we write down that the applicant undertakes to abide by all the terms and conditions which may be imposed while granting the anticipatory bail to him. The present applicant further undertakes that he will remain present on all hearings before the court of law until the completion of trial. Then whatever the agreements that the present applicant says, like the present applicant has not filed any other application before the High Court or the Honorable Supreme Court of India, the applicant fails to amend, alter, delete, or modify any of the foregoing grounds as and when necessary, Wakalatnama signed, and therefore the applicant most respectfully places under whatever the prayer that is to be given in such a case. That was what the that is how the application for the grant of anticipatory bail is to be drafted, and that was what the anticipatory bail under section 438 includes. Thank you.